Even the people don't have the authority to grant unjust powers to a government. And one of the examples of the king exercising unjust powers is setting the military up as superior to the civil administration. Well, that's martial law. None of that is there. All of the rationalizations for martial law are absent in the Constitution of the United States. Why does the leadership group in this country not concerned with having the militia structure as opposed to the National Guard and Homeland Security, whatever institutions they've created? For the very simple reason that I think they understood certainly at the turn of the 20th century when they created the present situation. They didn't want the people to exercise that level of sovereign authority. They didn't want the people to recognize that they could be independent in some important sense of the bureaucracy or the expertise group at the higher levels of the governmental pyramid. The idea ultimately was, of course, to suck sovereignty, as it were, out of the hands and control of the people into this bureaucracy. The bureaucracy would now become the sovereigns. The bureaucracy would write the laws in the guise of regulations. Congress would have no oversight over this because Congress could certainly not take the time or have the expertise to review every one of these regulations as they came out, the thousands and thousands of pages of the Federal Register that come out each year. It's physically impossible for Congress to deal with this. The people don't understand any of this by hypothesis. The administrative state theorists said, well, the people are ignorant. They can't do this. They can't pass judgment on these questions. So all we want to do is we want to have the people elect the politicians. The politicians appoint the administrators and give them broad-based authority to regulate. And then Congress tax the people, or through the Federal Reserve System, inflate the currency so that we'll have money to give to the administrators to execute these programs. That was the goal. And one part of this process had to be making sure that the people never woke up to the fact that they were the ultimate arbiters of sovereignty through these institutions called the militia, which could perform a lot of the functions that the administrative agencies were being called upon to perform. So you get around this whole problem of an entity that has military authority executing the laws, which is independent of and perhaps antagonistic to the general population. I mean, that's the key. All of these martial law situations tend to be predicated on the idea that the military force is separate from, independent of, and probably antagonistic to the people against whom they're executing the laws. That's why they're there. They have to be put in because there's this problem. They have to get control of a situation, and they get control of the situation by stomping on the rights of the people that they're supposedly controlling. Well, you don't have that when the people who are performing that function are the community people.
As a responsible person with growing concerns for your privacy and personal liberty, you want to know where we're headed and what you can do about it. We ask the experts what you need to do to take prudent and responsible action to safeguard your family's wealth and well-being, and what basic first steps will help you to be aware and prepared. ReluctantPreppers.com.
Before we started the interview, you were talking to me about some of the principles that you had unearthed and made a convincing analysis of dynamics surrounding whether it's possible or defensible to deploy martial law. We want to get a summary by you of your book called By Tyranny Out of Necessity, the Unconstitutionality of Martial Law. And we have a question from a viewer about that, but I think that you can not only answer that question, but bring us to an understanding of martial law and its reasonableness or whether it's not. We have Joe Puffenbarger II who asks, how is martial law possible when we have a constitution? Since I am born with certain inalienable rights, isn't martial law and declaring a, quote, state of emergency immoral and a crime against humanity?
Well, we don't have to go quite that far. It's unconstitutional, and you can add all sorts of further indictments of it, but it's clearly unconstitutional. Of course, you have to define martial law. The basic concept is that a standing army-type structure takes over in a particular geographical area, and then more or less makes the word of the commanding officer the law in that situation. That's the extreme example of martial law. Perhaps a less extreme example would be particular laws that are already on the books being enforced by military authority. So they would be enforced in a more strict, more draconian manner than the actual laws would provide in the civil context. So if you ask, well, where is this in the U.S. Constitution? And the answer is, well, it isn't there. And people come up with all sorts of excuses. Well, it's an emergency situation. In an emergency, we can do this. Or it's existentially necessary. This is the only way we can deal with some kind of problem. So we have to have the transference of authority from the civil branch of government to the military branch. Now, what's interesting is that if you start off before the Constitution, because we have the Declaration of Independence, and the Declaration of Independence is an interesting legal document because it starts off with a set of principles, and then based on those principles, it gives us an indictment, a list of charges against the king and his ministers, George III and his ministers, that are that his actions were inconsistent with the basic principles that were enunciated early in the document. And what is one of those?
Right.
He has affected to render the military independent of and superior to the civil power. Well, that's, in a nutshell, that's martial law. Okay?
True.
And actually, he hadn't even gone that far. In Boston, you had General Gage, who was made the military governor of Massachusetts. And he stopped town meetings, and he tried to control the provincial legislature. He wasn't too effective in that. But he had not gone quite as far as the Declaration points out. So the Declaration takes that as an example of a violation of the laws of nature and of nature's God, right? And it takes that as an example of an unjust power. Because the Declaration, the principle is, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Even the governed, even the people don't have the authority to grant unjust powers to a government. And one of the examples of the king exercising unjust powers is setting the military up as superior to the civil administration. Well, that's martial law. So right in the Declaration of Independence says, well, martial law is something that is contrary to the principles of a free government, and it's something which even the people themselves cannot institute. So one would think that if you look in the Constitution of the United States, you would find no provision for martial law, and in fact you don't. And in fact you find no provision for emergency powers. And you find no provision for setting aside the Constitution if public officials, the president or Congress, deems it, quote, necessary, unquote, the necessity doctrine. None of that is there. All of the rationalizations for martial law are absent in the Constitution of the United States. And they're clearly, martial law itself is excoriated in the Declaration of Independence. So where is it? What is the justification? What is the rationalization? What is the exoneration? What is the excuse? It doesn't exist. This thing is a fallacy in one sense, and it's an imposition in another. And of course, the worst of it is that martial law is imposed by what? The standing army. And the one thing we know about standing armies in terms of the context of the framers of the constitutional framers, founding fathers as they're called, were deathly suspicious of standing armies. And that's why the Army provision of the Constitution says that Congress has the power to raise and support armies, but the appropriations can last for only 2 years. They recognized they might need a standing army, but they wanted it limited. Limited how? By the ability of the House of Representatives, which is elected every 2 years, to cut off the funding. And there's another provision that says that there can be no appropriations taken from the Treasury, no money taken from the Treasury except pursuant to appropriations written by law, mandated by law. So if a new House of Representatives comes in pursuant to an election, looks at the situation, says, well, this standing army is dangerous or unnecessary, it simply doesn't vote the appropriation, standing army disappears. So the standing army is not really what I would call a permanent part of the Constitution. It's a contingent part of the Constitution, depending on how the House of Representatives views this situation, because it takes only one House to get rid of the appropriation. House votes against it, it's gone. Mm-hmm. Now, the other provision in the Constitution which is of consequence here is, of course, the militia provisions. Article 1, Section 8, Clause 15, Congress shall have the power to call forth the militia to execute the laws of the Union. Now you see, there we go. There's something that looks like, quote-unquote, martial law. Why? Because the militia are paramilitary-type organizations. As you can see from the other two powers of the militia in the Constitution, in that section, to suppress insurrections and to repel invasions. In fact, to repel invasions, you say, well, they're more than paramilitary. They would have to function as really military if you're going to repel an invasion. But certainly executing the laws of the Union, that's a kind of police function. And it can be done by these paramilitary militia structures. Well, why do we not fear that? I mean, why didn't the Constitution say Congress shall have the power to call forth the Army to execute the laws of the Union? Well, because they were definitely afraid of the Army. That's the last thing they wanted, was the Army exercising that kind of power. But they give that kind of power to the militia, or they recognize that kind of power in the militia, because actually the militia had that power pre-Constitution. Because the militia is composed of whom? The body of the people trained to arms and armed. Right? It's the people themselves who are enforcing their own laws. And for heaven's sakes, if the people themselves can't be entrusted to enforce their own laws, who can be, in principle? Right? So this book that I wrote several years ago, by Tyranny Out of Necessity, The Bastardy of Martial Law, because it's an illegitimate function. I'm using bastardy in that sense, right? By tyranny out of necessity is because necessity is often used as the excuse for martial law, and then that leads to tyranny. And the Praetorian Guard type situation in the Roman Empire is your classic example of that, historical example of it.
And that's exactly what the common answer will be. If you pose the questions, and I haven't been interjecting answers, you've been asking several rhetorical questions, but one that you asked is, why, if there is no constitutional basis or justification for martial law, why do we even have it? Why do we even allow it? And the common answer, the common person would give you on the street is, well, when you have riots, when you have epidemics, when you have these force majeure situations that are happening, we need some big, strong hand to come in and take care of it.
The Founding Fathers were not children. They recognized that these kinds of problems arose. So you would expect that in the Constitution they put some mechanism, some institutional structure to deal with them. The reason that people, say today, will acquiesce in the imposition of martial law, usually by the National Guard people, is that they don't realize that there is another institution within the Constitution which is supposed to deal with this problem. It's not that there isn't anything else and therefore we have to go to the National Guard or maybe call in the Chinese Women's Army or something, right? Because we have nothing else that can deal with this. Actually, the Constitution does provide. That's the thing that amazes me, because if you look at that provision dealing with the militia that I just quoted, Congress shall have the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. And you just take that template of words, and you can apply that to any one of these vicissitudes of life. National disaster. Natural disaster, right? Congress has passed some law. When a natural disaster occurs, the militia will do this. Or the states will have the power to, or we'll provide money for the states and militia, whatever it will be. You can imagine the states doing the same thing at the local level. Right? It's not that the institution is not there. It's there. Or the 50 of them, because there's one in each state. And specifically, the powers at the national level are spelled out. If you wanted to define Homeland Security as a generality, what would be better than saying execute the laws of the Union, suppress insurrections, and repel invasions? What would you have not covered? Right? Space aliens coming in, maybe, but there might be a law dealing with space aliens, or Congress could pass that law. Right? That
sounds like we weren't missing the Department of Homeland Security. We were missing the Department of Constitutional Understanding.
We don't need the Department of Homeland Security, number one. Number two, we don't need to call out the little standing armies of the states, the National Guard, because and have martial law in the classic sense, the army conducting these affairs, because we already have this structure built into the Constitution. It's right there. It's explicit. Now, why don't we have it? That's the question. I mean, the average person doesn't know about this at all, right? But why does the leadership group in this country not concerned with having the militia structure as opposed to the National Guard and Homeland Security, whatever institutions they've created? For the very simple reason that I think they understood certainly at the turn of the 20th century when they created the present situation. They didn't want the people to exercise that level of sovereign authority. They didn't want the people to recognize that they could be independent in some important sense of the bureaucracy or the expertise group at the higher levels of the governmental pyramid. Remember, at the turn of the 20th century, they had this theory of administrative government that came to the fore. A lot of economists and political scientists, if you will, political theorists in this country went over to Germany, Wilhelmine Germany, and they studied things like Bismarck's Social Security plan and so forth. And they came back to the United States with a concept of a planned economic and political structure. And the idea was, basically, that things were too complicated to be run on the constitutional basis. People didn't understand what their needs were. They didn't understand how to deal with these problems. And even Congress couldn't do that. It was a talking shop. It was a committee. You could never really get anything through them. What was needed was government of experts. And what would be done is Congress would create what we now know as administrative agencies made up of experts, each one focusing on a particular area or particular problem. Congress would fund these agencies, and the agencies would write the regulations with the force of law that Congress couldn't do because it was just too complicated to do that in Congress. Congress didn't have the expertise, didn't have the time, and so forth and so on. Congress would create the agencies and fund them, and then the purpose of the people in this system would be to elect to Congress the politicians who would continue to expand the administrative state. And this is exactly what happened, right? And the idea ultimately was, of course, to suck sovereignty, as it were, out of the hands and control of the people into this bureaucracy. The bureaucracy would now become the sovereigns. The bureaucracy would write the laws in the guise of regulations. Congress would have no oversight over this because Congress could certainly not take the time or have the expertise to review every one of these regulations as they came out. The thousands and thousands of pages of the Federal Register that come out each year. It's physically impossible for Congress to deal with this. The people don't understand any of this by hypothesis. The administrative state theorists said, well, the people are ignorant. They can't do this. They can't pass judgment on these questions. So all we want to do is we want to have the people elect the politicians appoint the administrators and give them broad-based authority to regulate, and then Congress tax the people, or through the Federal Reserve System, inflate the currency, so that we'll have money to give to the administrators to execute these programs. That was the goal. And one part of this process had to be making sure that the people never woke up to the fact that they were the ultimate arbiters of sovereignty through these institutions called the militia, which could perform a lot of the functions that the administrative agencies were being called upon to perform. Right? You think about an administrative agency of the Interior Department. I think of the Bundy Ranch situation, where they're out there regulating and controlling these so-called public lands. Leave aside the question of whether the public lands are really legitimately in the hands of the federal government. So you got this bureaucracy that's writing regulations, then enforcing those regulations. Now, if you had the militia doing that in each locality, wouldn't it be more efficient? Wouldn't it be more attuned to the needs of the people that live there? Wouldn't it be less confrontational?
Subsidiarity, absolutely.
Wouldn't the people themselves who are participating in this as the militia administrators, the people executing the laws of Congress with respect to those lands, be expected to be more fair, more insightful? Right? But then, if you did that, those people at that level, both the ones who were doing the local regulation and the ones they were regulating, all being part of the same basic militia structure, would realize, oh, wait a minute, we really have the authority here. And when somebody from Washington tells us that this regulation should be interpreted this way or misinterpreted this way, we're not going to do that. Just like what's happened in Virginia, right? The local jurisdiction saying, we're not going to enforce these Second Amendment violations that you people in Richmond think you're going to pass. Wrong. All right? And they don't even have a militia structure here in Virginia that works. But if you actually had the structure, that's what would occur. This whole administrative concept of sucking power to the top of the pyramid, to the all-seeing eye, would be broken down immediately. Because the administrators ultimately would have, the administrators in Washington or in Richmond, wherever, would not have the actual power, the force, to impose their wills. They could make recommendations if we still had administrative agencies. They could make recommendations and they could pass regulations, but if the local people said, this isn't going to work here, this isn't going to work in Nevada, we're not going to do this, that'd be the end of it. Because who's executing the laws there? It's those people. It's the militia people who are executing the laws. Right. It's not some administrator in Washington that's going to tell them what to do. It's going to work the other way around. So you could have expertise, the best aspect of expertise. The experts would look at a situation and say, well, we think this is what ought to be done because we have some scientific insight or whatever. Okay? And so we're going to propose these regulations. And then the locals will look at it and say, no, that's not going to work here. Because we have some special concerns or some special circumstances or peculiarities, or this is not going to work. And here's what we're going to do. And if you don't like that, you can suck on an egg in Washington. Because you don't have the authority to enforce, you don't have the ability, let's say the authority, you don't have the ability to enforce these things against us. And Congress could and should write the laws that way. So that would completely reverse this whole administrative state pyramid that had been created since the early 1900s. The overarching, over-penetrating bureaucracy would essentially disappear. You'd have administrative agencies, the experts would be there, and they'd be thinking about these problems. And then all of the actual, quote, administration, unquote, execution of the laws would be done at the local level by the local people who saw how these recommendations from the agencies were working in practice. And there's absolutely no reason that Congress couldn't write the laws that way. Right? But except that the political class, the elitists, don't want the people to have that authority. They don't want this to be a free state or a composition of 50 free states. True Republican form of government. They want it to be an elitist, top-down controlled system in which the people are, in a sense, they're an embarrassment that we even have to deal with them. It would be much nicer if they didn't even vote, because that's a complication. It just creates all sorts of stupid problems. Let's just get rid of that. That would be, to me, if I were in their shoes, that would be my next step. Let's figure some way that we can stop these people from voting, so we don't have to go through that. And sometimes get people in Congress like Ron Paul. We don't want that.
Right.
Yeah, aberrations like that should be stopped, right?
Well,
so that would be the next step in the administration. Let's remove all of that nonsense. Just tell the people it's unnecessary. It's a waste of time, right? But whatever, give them some excuse. But you look at that structure and you say, well, of course, it's the pyramidal structure. There's the all-seeing eye at the top. That's where all the power has been centralized, all the wisdom and power. And then down below, we have somewhere in the middle, the states. There's a little bit of wisdom and power there. and then go down a little further to the local jurisdictions, and there's even less wisdom and less power there. And then the very base of the pyramid is the masses, made up of the masses, and there's no power and no wisdom there at all. They are just like political cannon fodder. We use them to get the votes, and we use them to pay the taxes, and then we abuse them in every possible way. Now, the reality, in terms of architecture, what's the strongest part of the pyramid? It's always the base. Right? If the base doesn't hold up the rest of it, the pyramid collapses.
Right.
A society is only as strong as those ordinary people that make up, what's the expression, warp and woof, if you will, of the social structure. Every society in history that eventually, what shall I say, deteriorates is the word, devolves into a kind of administrative super-state system is not long for this world. And the simple reason, go back to someone like the Misesians, the Austrian economists. Where is all the knowledge in society that's necessary to make society function? Well, it's not in some administrative agency in Washington, D.C. They may think it is, but it isn't. It's down there among the people themselves, because that knowledge is being generated on a real-time basis. And by the time the information gets up to Washington, it's already outdated. You can't run a society centralized that way, certainly not a free society, simply because of the information problem. So this whole administrative state structure is doomed to fail, no matter how many computers they have, or experts, gurus, technical gurus. But the reason they set it up was, I think they probably honestly believed that they could make it work. But on the other hand, they had to be dishonest. They had to lie to the people about what was really happening. And they had to pass, and I come back to the 1903, the Dick Act, so-called. They had to remove the people from that institutional structure, which might have proven to be a stumbling block to the consolidation of administrative power, the militia. As long as the administrative state had to look at this thing down below and say, oh my God, that militia structure could turn against us at any moment, and they are armed, organized, trained, etc., to do it, we're walking on a broken glass. We have to get rid of that. That's the most important thing. And we can substitute for the things that would have done. Then we substitute these military components. We create this thing called the National Guard. We create the state troops so we can have more troops. Just in time for World War I, by the way. All right, it's kind of an interesting coincidence that happened. So we'll create these troops, and then we'll come up with this set of excuses, rationalizations, for martial law, for using these troops, the Army, the National Guard, whatever, the Homeland Security, the militarized local police, for using these people this way. Oh, yes, we won't be able to find any actual provisions of the Constitution that say that. In fact, we'll have to pretend that certain provisions of the Constitution aren't even there, the ones dealing with the militia. But most people are pretty stupid. They're not going to figure this out. They go to public schools. They never read about the Constitution. They go to Harvard Law School. They don't read the Constitution. And we'll get away with it. And you know what happened? They were right. They got away with it. That's the thing I find most fascinating. They got away with it. I go back once to Harvard, again to Harvard Law School. There was no, what shall I say, shock, surprise, dissent in that constitutional law class based on the fact that we were never asked to read the Constitution. Nobody put up his hand and said, Mr. Cox, why aren't we reading the Constitution? I knew why we weren't reading the Constitution. So I didn't even have to get involved in that. But I would have thought that some naive child would have put his hands up and say, why aren't we reading the Constitution? Is this a constitutional law class? Why aren't we reading that? All right. Take the antitrust class and you read the antitrust laws. You take the civil procedure class and you read the federal rules of civil procedure. And on we go. And I think the answer was because there were provisions of the Constitution for which they didn't have a rationalization for denying, right? Look at any constitutional law text you want and see how many pages it devotes to the militia. I was going to say you'd be surprised, but after hearing me, you wouldn't be surprised. It's essentially nothing. Essentially nothing there.
Well, we have to make. We're doing our best to make sure that more people hear you.
But so I'm not surprised by this. But if you look at the history, the development of this, it's precisely why martial law is now something that is talked about, and people fear this. They say, "Oh my goodness, if such and such happens, we're going to have martial law." This is going to happen. There's no question this is going to happen. And it's because it's necessary. It's because there's an emergency and they come up with these rationalizations. And nobody steps back from that. This is the emperor's new clothes phenomenon or the man behind the curtain in the Wizard of Oz. Nobody steps back and says, wait a minute, why? Could the founders of this country have been so naive? Could they have been so unworldly? Could they have been so stupid that they left out of the Constitution of the United States provisions for dealing with these emergency types of situations? That they gave us no institutions for doing this other than the Army. Oh, which, by the way, they said the Congress could eliminate. So we'd have nothing. Is that what we were left with? Well, my goodness, they were certainly a historical failure, weren't they? It's no wonder that the progressives want to tear down their statues. All right? But the reality is they weren't that stupid. We're that stupid. Well, speak for yourself, as it were. I try not to be stupid. But we are that stupid now because we don't go back and look at the document and say, well, now, what do you think this means? Why is this here? Provisions for these things called the militia. It's in the plural, right? What are they?
Yeah.
Why are these? They don't give the power to execute the laws to the Army. My heavens, they don't give the power to repel invasions to the Army. All it says is Congress can provide for an army, provide and support an army, but it doesn't give these specific powers to the Army. That's strange in and of itself. Especially today because we see the National Guard part of the Army and suppressing insurrections, executing the laws when we have natural disasters and so forth. So you would think the average person would read that document and say, there's a real anomaly here in terms of what this thing says and what we're told we need to do today. It's a real discrepancy in the document and its apparent implementation. And all I would say to anybody, let's put a stack of Krugerrands about 8 inches high on the table. You put yours there and I'll put mine there. And then you show me where in the Constitution there's martial law. If I did that a few times, I could retire. Right. And actually there is. I mean, the concept martial law, in the broad sense, is there in the militia. Executing the laws of the Union by a paramilitary organization if they needed to use paramilitary force. Right. Most likely it would be executing the laws in the same way the civil authorities execute the laws today, or the local police execute the laws today if you get to the police level. Probably the same for suppression of insurrections. It would only be when you get to real insurrections, heavy-duty insurrections and repelling invasions, that you'd see a military component of the militia come forth. But even then, that military component of the militia would be controlled by what? The militia as a whole, which is a civil institution made up of the body of the people, as the expression used to be used. So you get around this whole problem of an entity that has military authority executing the laws, which is independent of and perhaps antagonistic to the general population. I mean, that's the key. All of these martial law situations tend to be predicated on the idea that the military force is separate from, independent of, and probably antagonistic to the people against whom they're executing the laws. That's why they're there. They have to be put in because there's this problem. They have to get control of a situation, and they get control of the situation by stomping on the rights of the people that they're supposedly controlling. Well, you don't have that when the people who are performing that function are the community people. You're not going to stomp on even in a natural emergency situation. You're not going to necessarily go across the street and stomp on the rights of your neighbor. Well, of course not. He's probably a member of the same militia company you are. He's performing the same function you are. You've been trained to work with him, to appreciate him as a member of not only your militia structure, but your social network. So that antagonism business drops out immediately. There's no longer the us versus them. There's just the us. And you would think the average person today, even somebody who calls himself a progressive, they're always talking about equality and fairness and justice, and they're against racism and whatever. Well, what institution in the Constitution fits all of that terminology? One institution in the Constitution would be made up of all members of society, performing whatever functions they could perform, seeking, quote-unquote, social justice, right? You start adding all those progressive terms, which in many instances don't have real-world reference. But what institution could you imagine that could actually perform those functions in those ways? Will be the ones that were made up of the body of the people, the entirety of society, working in some kind of harmonious measure because they were all faced with the same problems. Now, of course, you're going to have antagonisms, you're going to have conflicts, you're going to have jealousies, and that's just the human conditions, the way humans are. But you're trying to minimize those by getting everyone to realize that we're working on a common project. We can't afford to let those defects, personality defects, if you will, impinge on this goal. And if we have some people in the organization who simply refuse to accept that proposition, then we have some kind of disciplines imposed upon them. So they get straightened out or removed or whatever very quickly. And it's done, once again, at the local level. This is not an imposition that's coming from nameless, faceless bureaucrats who have nothing but antagonism towards us. No connection with us, no sympathy for us. It's just the opposite. So I don't know. I mean, I would think that if there were anyone in society today, in principle, based upon the way they talk, who would be in favor of revitalization of the militia, it would be the so-called progressives. I'm leaving aside the ones who are, the actual Marxists. They've got another agenda entirely. But the kind of fuzzy progressives, they talk about these generalized terms, social justice, cooperation, et cetera, et cetera. Okay.
So, yeah, rather than identifying groups to hand out things to, you just say, how about actually engaging and empowering and educating in the proper roots of our country and giving them real responsibility and necessity and so on. Right? Yeah, why not?
Well, it's more than why not. I mean, I don't think it's even a question. I don't think there's an alternative. This is what should be done. The alternative is this mess that we have now.
Yeah. Hypothetically Correct asks, if public officials are sworn to protect the Constitution, what act or authority allows them to legally nullify the Constitution in courts, and what remedy or redress do citizens have?
Well, the answer to the first part of it is none. If you take an oath or affirmation to support the Constitution says you are to be bound by that. They shall be bound by oath or affirmation to support this Constitution. And that provision, Article 6, Clause 3, is made the supreme law of the land with respect to the states and the localities and the federal government by Article 6, Clause 2. All right? So now what does it mean to be bound? Well, something has to happen to you if you violate your oath or affirmation. Otherwise, you're not bound. Right? If there's no consequence to bad behavior, then it's a paper tiger, a toothless paper tiger, that provision of the Constitution.
Just briefly, I'll interject here because it's a great quote by another Cajun Jameis who puts Thomas Jefferson's quote in here, quote, "Let no more be said of putting trust in men, bind them down by the chains of the Constitution."
Well, there you go.
Go ahead.
And it has to be that way. So now you ask, well, what happens if an office holder violates his oath? Well, we actually have statutes to deal with that. If he violates his oath to the Constitution, the consequence is generally that he has violated someone's constitutional right. That office holder has taken an unconstitutional action, and there will be some victim, some target or some victim. And that person will have a civil remedy. Title 42 of the United States Code, Section 1983 is a classic example of that. Anyone who, under color of law, deprives a person of civil rights. There are criminal statutes that deal with that. Title 18 of the United States Code, Sections 241, 242. 241 is a conspiracy statute if people conspire to do that, and 242 is if an individual does it by himself. So you can be criminally prosecuted for violating a person's constitutional rights when you're acting under color of law. And, of course, if you're acting under color of law, then you are probably, almost certainly, a public official who has taken an oath or affirmation to support the Constitution, and you're violating that oath. Now, one of the difficulties you have is, of course, these people invent excuses for themselves. They invent avenues of escape. And one of those avenues of escape is so-called immunity doctrine. So you had the Supreme Court of the United States inventing this, in fact, dealing with that statute that I just mentioned, 1983, Section 1983 of Title 42. They said, well, you know, the Congress could not have meant to apply this in all circumstances to public officials. And if the right that they're violating is not clearly established, then you can't sue them for damages, for monetary damages. Right has to be clearly established. Now, you can sue them for an injunction, declaratory judgment, but you can't sue them for monetary damages. So a public official, if he's not sued for monetary, you don't have to pay money. An injunction is probably not something that's going to discipline him personally. Now, where did this come from? Well, they invented it. 42 U.S.C. 1983 derived from Reconstruction after the Civil War. And the problem at that time, as seen by Congress, was that the officials who came into power in the southern states, that previously members of the Confederacy, they were violating the rights of the freed slaves, the freedmen as they were called, and they were violating the rights of the white Unionists, the people who had been in the Confederate States who had opposed secession, or who had fled the state and then came back to the state after the war was over. So it was clear that Congress wanted to come down very hard, very strictly on this kind of behavior. Because actually there was a history of that kind of behavior even before the Civil War, dealing with people who vocally opposed slavery in the slave states, not to mention the slaves. So you would say that, if anything, if Congress didn't mention in the statute that there was a possibility for immunity, that immunity wouldn't exist. Right? If it's not in the statute, it's not there. You don't read things into a statute that aren't there. Well, why did the Supreme Court do this? Well, because they wanted to give an out to these public officials, give them a way to evade having to pay, even though it was the taxpayers that always end up paying, for violations of constitutional rights. So you have these immunity doctrines. They're called qualified immunity because if the Supreme Court ever rules in that type of case and says this particular type of behavior is a constitutional violation, then the immunity doesn't apply in the future. Someone who performs that type of misbehavior cannot claim qualified immunity. But he gets at least one bite of the apple. And this makes these cases, in many instances, problematical because you have to find a set of circumstances which are very close to a set of circumstances that the courts have held to be constitutional violations. And what does that require? Well, it requires lawyers and money and lots of time and so forth and so on. And as a result of that, you have public officials and certainly administrators, the unelected, the appointed people. They're not too worried about this. about being sued in civil rights cases. There's not some real fear that I have to walk a very straight line or else I'm going to find myself in court tomorrow morning. Oh, no. I used to do this kind of stuff. I used to sue public employers in lots of cases, and they kind of shrug their shoulders about it. Yeah, this happens. We got lawyers. We'll litigate this. No problem. No problem.
Wow.
And, of course, some of these things these violations are really grotesque if you look at what's being done. I take the Second Amendment one as a classic example because you can make, or I can have made, an argument from the Constitution that quite a bit of this gun control is actually treasonous behavior. Because, number one, in order to enforce it, you have to send out armed thugs to attack people, and that's what's called levying war on the people of the United States because they're simply exercising their militia right, their governmental right, for heaven's sake, to have a gun. And then, of course, if you would disarm, the more you disarm the people of this country, the more you give aid and comfort to the enemies of this country who look at the situation and say, wow, these people can't defend themselves, which means that we can push them in foreign policy situations, or maybe we can invade. Who knows what that would be? And so I look at that and I say, no, there's a kind of a classic example of where those legislators are working in direct contradiction to undermine the Constitution of the United States. And that's treasonous activity if there ever was treasonous activity. Well, exactly how would you get that enforced in the judicial system? You'd come up right away against these immunity doctrines. They say, oh, well, no court has ever held that to be the case. And so they skate. And that's why you have all over the country these draconian gun control laws, especially the newer ones which deal with the obvious militia-suitable firearms, the AR-15 types. So there's a difficulty. There's a major difficulty. And then, of course, you have a political difficulty, which is going back to the criminal statutes. Here are these criminal statutes, and they were designed to deal with things like the KKK in the Reconstruction period and the corrupt Southern governments that were denying rights to the freed slaves and so forth. And there's no immunity involved there. Even the Supreme Court has not dared to say that a public official can claim immunity from a criminal violation. But they get practical immunity. Why? Because the prosecutors don't prosecute them. Right? Say you have a police brutality case. Right? Policeman shoots somebody 7 times. Oh, he had his hands up. It actually turns out to be the wrong person in any event. It's not the real suspect. It's someone who was mistaken for the suspect. And the prosecutor say, well, this was just an accident. Instead of recognizing they had a gun-happy cop who was looking for an opportunity to shoot someone. And at a minimum, he was engaged in manslaughter, let alone murder. So the prosecutors do this as a matter of practice. Why? Because the prosecutors and the local police have to work together. Right? You want the local police to come up with the evidence. You want the local police sometimes to fudge the evidence, what have you. Right? You can't be taking them to court on a regular basis on criminal charges because of some of the excesses in which they engage. So they have another problem, that the people who are supposed to be enforcing these oaths or affirmations, the people who are supposed to make sure that the public officials are bound by their oaths or affirmations, are themselves not being bound by their oaths or affirmations. I mean, if I were a prosecutor, although prosecutors have a certain amount of discretion, they can bring a case and not bring a case, especially if they think, well, this case is marginal. I'm not going to take this in front of the grand jury because I don't think I can get an indictment. But otherwise, they have an obligation to enforce the laws against anyone who violates them. Doesn't matter whether he's a policeman or not. Doesn't matter whether he's a legislator or not. But what we see is the upper level, the political crust on the pie, as it were. These people have practical immunity. They have judicial immunity because the courts have given this to them in the civil area, and they have practical immunity in the criminal area. And what does that do? Well, if you remove deterrence, you increase the level of improper behavior. Right? If I'm not going to be punished in some way for behaving improperly, it's much more likely if I'm a weak personality or a psychopath that I am going to behave to the maximum degree improperly. Because it's to my benefit to do that. I'm sure all your listeners are aware of the theory of public choice, which says that you need to analyze, or you ought to analyze, it's useful to analyze political decision-making in government in economic terms. That is, what's in it for the politician. Not the politician paying attention to legal principles, but looking at some kind of return that he's going to get personally from this. Whether it's a bribe, whether it's inside information that he can play on the stock market, whether it's a job in a defense company once he goes out, leaves Congress, whatever it may be. And that when you look at it that way, you suddenly discover that you have two kinds of government. You have some government that's being run on legal principles, but more government that's being run on these economic incentives. And most of the economic incentives are ones that probably at least skirt, if they don't violate, the oath or affirmation to support the Constitution. Okay?
Gotcha.
And so now we have an incentive-based, unconstitutional system that's working in the guise of government. And only people that have the ability to look at it, we have this right here in Front Royal. We've got a huge scandal here about a thing called the Economic Development Agency, which was being run as all sorts of monies were flowing through it, and it's just every day you pick up the local paper and there's some new part of the scandal that is being exposed. Well, this went on for years and years and years. How did they think they could get away with that? Well, because they didn't expect that the local jurisdictional body would look into it too deeply, or when they did, would kind of poo-poo the possibility of illegal activity, or the local prosecutors would investigate it. I mean, when the thing finally broke, they had to call in the state police to investigate it, to have an independent investigative body, because nobody trusted.
Sounds like they should have called the militia.
If you had the militia, see, that would be the interesting thing. If you had the militia, it probably never would have started in the first place. All right? But there's the difficulty. So the oath of office is there. It's extremely serious because if you violate the oath of office, by hypothesis, you're violating the Constitution. As a practical matter, you're always violating somebody's constitutional rights. There has to be a victim or a target, a subject of the thing you're doing in violation of your oath. And an oath was taken as a very serious matter in the founding era. Right? If you were a religious person, it was your eternal salvation or damnation that was involved in taking this thing and then violating it. Because if you were a Quaker or so forth, well, you couldn't swear, but you could take the affirmation, which may have had the same kind of in terrorem effect on you. Right? And otherwise, if you were violating your public duties, you had to expect, because those are people basically of honor in those days, you had to expect that somebody else was going to call you to account.
Right.
And this is the problem today. They're not called to account. Well, because they're all in it. Right? If I point my finger at you, you're going to point your finger at me, and we're both going to be, like mutual assured destruction. So we both say what? Nothing. All right?
That's going to open up a whole new chapter we've got to get into in a future discussion about the bewildering lack of candor in these, and then you get these rancorous debates about things that just seem so clickbait and sound bites on the news and everything, and all these feigned indignation on the parts of different political parties and doing exactly what the other ones was doing when they were in power 4 or 8 years ago or whatever. And meanwhile, you have the common people wondering, but knowing at a very deep gut level, the real elephants in the room aren't getting talked about and their fate, their power is going down the drain. Their economic plight is getting worse and worse. Their civil liberties are getting infringed on greater and greater every year. But then it plays back into something you talked about earlier, which was the bewildering complexity, the numbing complexity, the paralyzing complexity of the system by these experts and these bureaucracies and these stacks of documents so thick that the ordinary person feels like they're lost in a Kafka novel, and they really do feel powerless in a very real sense. Just try calling the IRS and trying to get through to somebody who can help you quickly and solve a problem. So we're going to have to circle back on that as well. And we've been just blessed beyond measure to have Dr. Edwin Vieira, constitutional attorney, visiting us again. And Dr. Vieira, we're going to have you back because I think we touched on 3 out of about 15 questions here. So just deeply appreciate you giving us a very illuminating and gravely concerning, but frankly optimistic if you look at it in principle, because I believe what you really showed us is you said you can't find martial law anywhere in the Constitution, but even without saying it, I think you convinced us that you can find the militia in the hearts of free men and women, and that's what we need to realize, is that the embers are not dead because the embers lie within our hearts of that justification of living in liberty, and we just need to reawaken that. So just really appreciate you joining us here to help us be encouraged to stand up and fight the good fight for educating ourselves on what is nearly lost awareness of our roots and our birthright.
How shall I put this? At my age, this is all I have to look forward to, that I'm going to change enough minds or open enough minds. Let's not say change, because a lot of people have never thought about this at all. They don't have an opinion.
Right.
You're going open enough minds to this so that they can see that there is a wealth of hope, if you want to use that word, in this system, which people are not drawing upon.
Yeah, it's latent. It's present and it's latent and it's ready to be tapped, and it just takes the awakening of people being, it's just, the moment I get fired up about this, I get overwhelmed with how it makes me angry and hopeful at the same time. Angry at the loss, at the systematic loss of knowledge of this, and then hopeful that we can regain that.
Well, you can't let a lot of energy go to anger, because that's all water over the dam.
Yep.
Right. You know what happened. We can attribute it to stupidity or avarice or all sorts of things.
Yeah.
But here we are.
Yes, and
now the question is, what are we going to do about where we're going with this?
Well, what we're going to do is we're going to put this information out there in front of 70,000 subscribers, and we're going to spread this knowledge, and they're going to forward it to other people, and
yeah, that's it.
We're going to have you back on. So.
You've got to energize the base of the pyramid.
Yeah, there you go, man.
And then right, that's all you can do.
Just thank you for joining us here on Finance and Liberty and Reluctant Preppers.
Well, thank you very much for having me. Anytime.
Reluctant Preppers provides educational awareness and commentary only. Opinions expressed do not constitute personalized financial advice. Viewers are encouraged to do their own research and seek qualified personal financial consultation before making investment decisions.